Well, Sarah Boone had a plan, a twisted little game. Jorge never saw it coming, but she knew just the same. In the darkness of the night, with a smile so sly, she whispered, "Let's play a game," and he didn't ask why. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Jorge was laughing, but his breath was thin. The walls were closing in as the fear kicked in. He called out a name, but it echoed in vain, while Sarah watched coldly, not a hint of pain. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly flame. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows. Morning came with silence, no breath to be found. Sarah unzipped the case, Jorge's last sound. She stared at the scene. What had she done? In the suitcase of love, there's no place to run. She zipped him up tight in the suitcase of love. No air, no light, just the stars above. He thought it was a joke, just a lover's embrace. Sarah, he cried in that tight, dark space. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly flame. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows. Love's a game of risk, a dangerous thing. In the suitcase of love, it's a deadly fling. Sarah's smile fades as the silence grows. In the suitcase of love, nobody knows.
What do you got?
I think I can prove to a judge that both of these men had the mens
Predator
rea.
passes out in the middle.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, everybody, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you're going to be doing it. I don't care. I'm just glad you're doing it here with me. How are we? We are getting ever closer to the start of the Sarah Boone trial. This may be the end of jury selection today. Maybe the end. It will be the end of the motions today, definitely. But it may be the end of jury selection. There's a teeny tiny chance that we'll start with the opening statements towards the end of the day, but I doubt it. Probably start tomorrow with opening statements. All right, I got to kill the background here because it's a thing, but it doesn't work well with hats because it always, depending how you sit, if you sit a little too far forward, it cuts things off there. But you know, if we wanted to like blind everybody with a reflection off the head, we could do that fine. But anyway, we'll just remove the background here. Give me a quick second. It was just a little fun and games for the day. Or maybe should we keep it? 1 in chat to keep it, 2 to get rid of it. That's our first poll of the day. A 1 in chat to get rid of it, 2 to keep it. It's all up to you guys. Noticing that the brim fades when I turn my head and whatnot. All right. We got lots of twos out of the gate. All right, looks like we got the mostly got twos. Yeah, twos are gonna win. All right. Later, Grizzly dude. There we go. Boom. Hey, it's me again. Back to the normal state of affairs. All right, everybody. We are here, as I was saying. Right now, let me put up the couple of banners here. The first banner we need is today, chat, all because of you and your awesomeness and all the support you show the channel all the time. We are on day 36 of our emotional support potato pig dog camera streak. We've got the pig dogs all lined. Well, yeah, we got both pig dogs lined up here. If we get to the achievement, if we get to that first hundy, that'll unleash the emotional support potato pig dogs, who will join us as our co-hosts for the remainder of the evening, so that you can enjoy their fuzziness, their laziness, their fatness, just like me, and taking emotional comfort in them during the difficult times of this trial. So it's up to you whether we make this day 37. Yesterday was day 36. Will today be day 37? That is entirely up to you, chat. And we seem to be a little bit on our way there. We'll address that in just a little bit. But as always, we have our like and subscribe poll set up. We got 328 people here right now, 158 likes. And just so if you're joining right now live, it just really doesn't mean much if you're joining later on the replay crew. But if you're watching live right now, the court is supposed to start right now, but this is not the first item of business. From our super secret spy in the courtroom, our courtroom reporter, Jules, she's told me the judge has to handle 14 sentencings this morning before he gets to the 2 remaining motions and then back to jury selection. Don't know how fast that'll go. Don't know how quickly or slowly, but I've got Law and Crime here. It's going live. We'll know when court starts because I'm watching. Until court starts, we will be watching yesterday's jury selection. So we'll see how the judge has conducted jury selection in this case. All right. So we do, for those of you 356 viewers, 186 likes, about 200 if you need to get down there to do your job. Sorry, but yeah, about 200 of you need to get on there and smash that like button. So please do that for me, and subscribe if you haven't already done so, because we are inching ever closer to 82,000. We are currently at 81,196. We will easily be to 81,200 by the end of the stream, possibly 81,300. It's entirely up to you. Again, take a risk on me, subscribe to the channel, and love everything that we do here, because we do it for you. And once you've done that, once you've hit the like button, once you've subscribed, and if you are subscribed, double check to make sure you're still subscribed, get on over here and take our like and subscribe poll. If you're watching on the replay, you can take the poll too, but just put your answer down there and chat. What would you choose? Today's like, subscribe, and vote poll is: what is your preferred Sarah Boone snack? What is your preferred snack for watching the Sarah Boone trial? Popcorn? It's classic. I'm a huge popcorn guy. Pop-Tarts? Sarah wanted her own Pop-Tarts apparently for to be provided at the state's expense, so she could snack on them at the defense table. So do you want popcorn? Do you want Pop-Tarts or chips or crisps, depending which side of the Atlantic Ocean you happen to be on? So potato chips or crisps, depending. And the last choice is gummies. All the gummies. You're going to need all the gummies to get through the trial. That's it. Just hit the like and subscribe poll. We'll check back in an hour or so and see what your choices are. And again, while we just sit around here and wait, let me put up the What We're Doing banner. This is our What We're Doing banner. Save that. And we're watching yesterday's jury selection. We're watching yesterday's jury selection while waiting for today's hearing to start. I think we should scroll that across the bottom. Let's scroll it. Is that going to scroll it? Scrolling. Keep that banner scrolling. Rawhide. Oh, well, okay. Well, Law and Crime has just swung their camera around from the great seal of the state of Florida to the clock. And for those of you that are new to these trials here on my channel, you'll know that we do one thing, and we'll have to do this for opening statements. Every day we will have a bingo card. And the bingo card will be linked to things that you're likely to see or likely to hear during the course of the trial. And we just get bingo. It's just fun. It seems like it's a little irreverent to do, but there's actually a method to my madness. going through the bingo, it sort of helps keep you focused on the trial and what's going on, what you're looking at and what you're hearing, so you don't miss what's on the bingo card. So I will prepare that for opening statements, and we will be ready to go with our bingo card as we do with other trials. Now, when we do the Leilani Simon trial, when she allegedly deleted her 20-month-old, we're not going to be doing a bingo card for that, but we will for Sarah Boone. We will be for Sarah Boone. All right. I think that's pretty much all the stuff we've got. So let's do this before we get going. Sonny or Chris has started us off the day, put us well on the path to unleashing the emotional support potato pig dogs. He has single-handedly put us 1/4 of the way there. Thank you so much, Sonny or Chris. If you happen to get one of those Sonny or Chris gifted memberships early on in the game, which was ill on 3, Bingo Brewty. Hey, you'll be ready for the bingo game tomorrow, Bingo Brewty. Young Black Economist got one. Honey 2800 got one, and KH got one. If you happen to be one of those people, make sure you go down there deep into the heart of the Louisiana Bayou and give Sonny or Chris a super special alligator-ridden thanks. Thank you so much for kicking us off. And Mismo, South Carolina, says, what's the deal with the snacks? Sarah Boone requested that the state provide her with snacks to nosh on during the trial. The judge said, yeah, don't think so. So that's what the snacks are all about. Matilda, all the way from the Netherlands, has dropped us a sticker. Behind the scenes. Thank you so much, Matilda. Good morning in the Netherlands from Korea. Jill Am's hitting us up with a $5 from Aussie Australia land. Aussie Australia, that's what I'm going to call her from now on. Sarah, shh. Bad woman. Thank you very much. We'll call magic. Take the deal, Sarah. Take the deal. You can't take the deal. There's no deal to take. We'll call. You know that. Saying it doesn't make it so. And if she takes the deal, then what are we going to do? Come on. Let's keep this going. Keep the gravy train running. We got emotional support potato pig dogs to feed and care for. Jill Am's woof woof drops another $5 Australia. Thank you so much. That puts us about 40 away from the emotional support potato pig dog cam achievement. $40 away from day 37. All right. Nothing is still happening over on Law and Crime Land. So what we're going to do, first, I will show you what's going on over in Law and Crime Land. This is what we're looking at right here, the clock. As soon as that moves into the court place, the court place, it has a name. The court place has a name. It's a courtroom.
That's why you're the judge and I'm the law talking guy, the lawyer. Right.
All right. So that's what I'm looking at. But we are going to go to something that happened yesterday. This, ladies and gentlemen, what you're watching here is darn near exclusive content. This is the jury selection from yesterday afternoon. And how did we get this jury selection from yesterday afternoon, you may ask? Well, we got that from Trial TV Live. That's who we got this from. We got this from Trial TV, a small YouTube channel that needs to be a very large YouTube channel very, very quickly. So please go down there and make sure you give those folks some love, because they have given me permission. They have given us permission to use their feed from inside the jury selection room. So that's incredibly danged awesome. Right now I'm looking for their link so that you folks can link it up. The good mods can post the link so you can go over there and like and subscribe to their stuff. Got it. Let me see. Trial TV Live is the name of the channel. So mods, if you could search for Trial TV Live, and it has this little logo down there, and post that in the chat so you can give them some props. They've currently got some people. Let's see. They currently have 3,290 subscribers. We need to boost those numbers. Make sure you get in there to Trial TV Live and subscribe to their channel. And all right, let's get on with this. We have a couple of more super chats to dig through, and then we shall commence with jury selection, which, as I said, is darn near exclusive content. Robin Lane with the $5 says emotional support potato pig dog cam. We are closing in all because of good people like you. Antoinette Kilpatrick, unleash the cuteness. The cuteness is locked and ready to go. They are locked and loaded and ready to rock and roll. And Kathy Michael, $5 released. Oh my Lord. Sorry. I thought, wow. All right. Wait a minute. Time out. That's a $40 chat. How did I not? I thought it said $4. I thought it was kind of a weird color. My brain took a while to engage. Oh my God. Thank you so much, Annette Kilpatrick. You get a super special foghorn for that. Thank you so much, Antoinette Kilpatrick. And Kathy Michael dropping the 5 to release the hounds. And dang, we didn't even get through the introduction today. And day 36 banner, this can just piss right off. We don't need that anymore because you guys have unleashed day 37 of the emotional support potato pig dogs. It is that time, ladies and gentlemen, the time that we know and love, and we always are happy to see, the time of day that we call this.
Release the hounds.
And we introduce you to our co-hosts for the day, our emotional support co-hosts right here, Yoda and Strawberry. That's Yoda's butt, and Strawberry, that's Strawberry's face. It seems they both want to be in the same bed there. Brother and sister English bulldogs. The Strawberry's the cute one. Yoda is dumber than a bucket of rocks, but we love him anyway. So, all right, ladies and gentlemen, thank you so much for that. That was quick. That was extraordinarily quick. So, thanks, guys. You guys rock. You're rock solid. Thanks. My heavens. Did I do that right? Wait. Hang on. 25. Yeah, good enough. I think I may have been a little. All right, just shut up and let's play it. All right, people, here we go. Here we go. We're going to go into jury selection from yesterday afternoon. Let's just chill and see how the judge handles it. Unfortunately, there are no closed captions. Let me unmute it. No, it's not muted. And as soon as there's any movement in the court, we will go live. Oh, my Lord, there is movement already. Shoot. Well, crap. That didn't take very long, did it? All right. We'll watch that on the breaks or something because the court is going live now. All right. Share a screen. And there we go. Well, I don't know if they're going live, but she's sitting there, which means they are going to kick this bad boy off here in a matter of minutes. And oh, it looks like she had some makeup done. Well, all righty then. We almost watched some exclusive content. Right. We have released the hounds anyway. Thank you so very much for that. Sarah's looking nice in a would that be a cream colored blouse or egg? Or I'm sure there's a better word than egg for it, but it looks sort of like eggnog. It's like eggnog colored blouse. I don't know. Is that a thing? I can't believe she was able to get makeup. Well, she could use a brush through that hair. I'm just saying. I'm not critiquing her, but she could use a little bit of a brush. She kind of got a wild few hairs there, which is why I shave my head because then I don't have to worry about shampoo or combing because I'm lazy that way. All right, super special shout out to our what do you want to call them? Our disobedient stepchildren over on Rumble. Good morning, Rumble people, or good evening, wherever you're at. And let's see. I want a lip reader. Oh, somebody's got it. Is that a canned Starbucks coffee? Ugh. Oh, speaking of those sorts of things, we do have the official Sarah Boone cocktail here with us today. The Sarah Boone cocktail, the Boone Tang cocktail. Tang, so we can make the Boone Tang joke. It's vodka and tang. That's what we got. The Boone Tang suitcase. Ooh. There's a little more Boone in there than there used to be. A little light on the tang. You got lots of Boone. A lot of Boone, little tang. Ooh. This could be interesting by the end of this this pint. She's smiling. Did she smell the vodka? I don't know. Yeah, we sell those. I nope at Coffee in the Can. Oh, all right, we're up.
William J. for the state.
Hey, how about letting us in on the conversation? Oh, they're swearing her in. Yeah, and for those of you that wonder, we're blocking.
Ma'am, good morning. Can you state your
This
full
alleged
name and
law.
date of birth for the record for me? All right, Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse.
Yellow.
She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type of written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Based on
The lawyers will be louder in a minute.
things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
And while he's doing that, how is my volume, chat? I should be just slightly loud, just 5-10% louder than the court, so that we get a good balance and you can hear me if I ever do need to talk over them. Just let me know how I'm doing there in chat, and we'll adjust accordingly once you start speaking again. And by the way, for those of you that aren't familiar with this, what happens was I try not to speak.
Madam Clerk is advised that the court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that. Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come up?
Yeah, don't delay it now.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then,
Wow.
Short of taking a break right now and having her create it, I don't know what else to tell you.
I don't know why we need to hear it now. Why can't he wait till 1:30 for the order to be written up?
State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay.
That kind of sounds like they might be doing opening statements this afternoon.
Correct. That's correct. Mr. J?
I just need that ruling so that enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Clerk, Madam Court Reporter can provide a rough draft of what was ordered yesterday. We could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that, but it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to
No
out-of-state
concerns.
witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Mr. Owens? How long do you think? 10, 15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Wow. Okay, that's interesting. Let's talk here for just a minute before we go watch jury selection from yesterday. It does sound like he wants to go, and he being the state prosecutor, that he wants to go with the opening statements today, at least jury instructions and opening statements. I kind of agree with the judge. Let him have a good night. Let him have a good afternoon and evening before they're sucked into this thing for 2 or 3 weeks straight. But he says, we got people from out of state. We got witnesses. We need to get them going. We can't waste any time. Let's use every waking moment to work on this trial. So, yeah. Dang. Special K says, oh, so not trial. No, it's right there in the title of the stream. Arguments on final outstanding motions. Trial will be happening later. They have to, he said it can take about 2 hours to wrap up jury selection, maybe. And then they'll probably take a break or something. We'll just have to see how it goes. Special K also says, Jeff, is this unreasonable of the state? No. He's the judge made this ruling, and he's like, hey, we need to make sure we know exactly what that ruling is so that we know how to proceed with our arguments. So make it in writing. We need it before we start opening statements so that we can have time to prepare and craft our opening statements, taking into account what was ordered yesterday. So yeah, it's not nobody objects to it. It was just like, all right, let's do it. You got this choice or that choice, make the choice. And they made the choice. And Jill M to the $5. I asked my husband if he wanted to go play hide and seek. And can I hide you in a suitcase that I zipped up? He said, WTF. Yeah, it's not a reasonable ask, is it? So, all right. From what the judge said, they're not going to write up the order. They're going to play it back and I guess let them take notes on it or whatnot. And then they'll come back. They'll argue. It sounds like they have one final motion to argue. Then they will proceed with jury selection. And then they will start with the arguments. I mean, with opening statements. So I'm in a bit of a bind as to what I need to do for that. Because I would assume they would start sometime in the afternoon. 1:30 p.m. their time is 2:30 a.m. my time. So what I'm thinking is when they finish up this motion, when they finish up the arguments on the motions and they take the break to do the jury selection, I'm going to end the stream and go to sleep. And depending on what the judge says, I will make a valiant effort to wake up to stream the opening statements live. So before I jump in the sack real quick, I'll set up a stream so that I can just go live. So I guess that's what I'm going to do. And tomorrow's Friday, so it'll suck at work, but hey, I can live with it. It's Friday. I think that's about it. So all right, while we wait for them, let's go back and watch yesterday's jury selection, shall we? as we planned on doing earlier. Share screen. And yesterday's jury selection. Now we got to change the banner again. Oh, let's embiggen it. And fast forward.
Answer truthfully.
All right. They're swearing in the group of jurors.
Everyone, please raise your right hands to be sworn, please. Do each of you swear or affirm to answer truthfully all questions asked of you as prospective jurors? So help you God. Thank you.
Thank you all. You may be seated. Good afternoon, members of our panel. Welcome now to Courtroom 23 Alpha of the Orange County Courthouse in the Circuit Court Criminal Division. As you may recall, my name is Judge Michael Kranick, and I will be the presiding judge in the case of the state of Florida versus Sarah Boone. I'm going to ask the state to please reintroduce themselves to you for this afternoon's proceedings.
Good afternoon. Dave Cacciatore, Assistant State Attorney. William J., Assistant State Attorney.
In the defense, if you could please introduce yourself and your client again to our panel.
Good afternoon. My name is James Owens. This is my client, Sarah Boone.
Good afternoon. Tony Henderson, co-counsel for Sarah Boone.
Good afternoon again. Kevin Beck, on behalf of Sarah Boone.
Good afternoon. Shelby Andrews, jury selection and trial consultant.
Good afternoon. Attorney Lauren Henderson, assisting the defense team.
Thank you. You can be seated. Before we get started, members of our panel, I wanted to confirm that you complied with the court's instructions that were given to you either on October the 14th or October the 15th, not to conduct any independent research or investigation, not to watch the local news or read local newspapers, and not to discuss this case with anyone, either in person or through
It's possible they'll be starting sometime in the afternoon.
With the court's instructions, please raise your paddles at this time. Record will reflect that all paddles have been raised. Members of the jury, I still have a couple of questions to go over with each and every one of you this afternoon before I turn over questioning to the state. Now, as we've discussed previously, either with you when you were with us on Monday or Tuesday, that this is a criminal case. And I want to go over a couple of important criminal concepts that you might be familiar with. Now, maybe you're familiar with this by virtue of schooling or watching TV or reading newspaper or books or just your own life experiences. But it's not every day that we get to see these criminal concepts played out in real life. So I want to take the opportunity to go over some of those with you now. The first is the presumption of innocence. In the United States of America, when you are charged with a crime, you are presumed innocent. It doesn't matter if it's an allegation of speeding or an allegation of murder. Miss Boone comes into this courtroom presumed innocent.
Absolutely correct.
If I was to ask one of you to render a verdict right now, what would your verdict be? So continuing from Monday or Tuesday, the interactive portion of our program, I'm going to be asking questions again. So does anybody want to take a jump at that? If I was to ask you to render a verdict right now, what it would be? Juror number 34. Yes, sir. Perfect. Not guilty. Does anybody disagree with that? Raise your paddles. Okay. No paddles. Does everyone agree with that? Raise your paddles if you agree with juror 34. Juror number 6, I don't see your paddle raised, sir.
Uh-oh.
Oh, there we go. All right, raise them up high for me. All right, record reflect all paddles have been raised. Thank you. Juror 34 is completely right. That's right. Your verdict right now would have to be not guilty or innocent because you have not seen or heard or observed anything to overcome that presumption of innocence. Does anyone have an issue with the fact that Miss Boone right now, as she sits, is absolutely not guilty? If you have a concern with that concept, please raise your paddle.
This judge is doing a fantastic job at this jury selection. I love the way he's doing this jury selection. And he's absolutely correct. She is 100% not guilty in the eyes of the law right now because there hasn't been a single piece of evidence against her submitted to court. Now, once it gets submitted, that's going to be a different story. But until then, she's 100% not guilty in the eyes of the law.
At this time, court sees no paddles. Does anyone think that just because of where Miss Boone is seated at the defense counsel's table, she must have done something wrong?
Everybody.
With that opinion, please raise your paddle at this time. Court sees no paddles.
That's a human bias, and that's really hard
One
to
of the other criminal concepts to address is if you're selected to be a juror in this case, it'll be your job to determine the facts, apply the law that I give you, and render a lawful verdict. This is the phrase of sitting in judgment. Now, I want you to understand that you're not going to be passing any moral judgments on the defendant. You're also not going to be imposing a fair and impartial sentence. That will be the court's job if, and only if, the state meets their burden beyond a reasonable doubt. That way, the role of the jury and the role of the judge are separate and they never overlap. With that being said, does anyone have any religious or moral concerns to act as a juror and sit in judgment in this case? Juror number 20. Yes, ma'am.
The old Jesus is the only judge defense from the juror.
Okay. But do you understand that you're not going to actually be rendering any judgment? Okay. Well, let me explain it to you this way. So if you're asked to serve as our juror in this case, right, you're going to listen to the evidence that the state presents. You're going to listen to the evidence that the defense presents if they put on a case. And then I'm going to explain the law to you. And then you'll have to apply that law to the facts to say, yes or no, did the state meet their burden of proof? Do you understand all that? Can you do that? Okay, I appreciate your honesty. Thank you, Bill. The lawyers may have some follow-up.
She's going to get booted out. She will be dismissed for cause, I bet.
Anyone else, moral or religious concerns by sitting in judgment? Raise your paddles. Okay. Court sees no paddles. The next concept is reasonable doubt. And I've used that a couple of times, both Monday and Tuesday, when I first had the opportunity to speak with you. We need to understand that the state of Florida is the one who has brought the charge against Ms. Boone in this case. And we need to understand that they are the ones that have the burden of proof in this case. The defense has a constitutional right to sit there and do absolutely nothing other than argue that the state has failed to meet that burden of proof because the defense has no burden. The burden is entirely upon the state of Florida during the course of this trial. Does anyone have an issue with the constitutional principle that the burden of proof stays with the state of Florida at all times to prove all allegations against Ms. Boone? If you have an issue with that concept, please raise your paddle at this time. Court sees no paddles. Does anyone here think that Miss Boone has to prove anything to you? If you have that opinion, please raise your paddle at this time. Court sees no paddles. Now, as I said, the state of Florida's burden is beyond a reasonable doubt. I'm now going to read to you the legal definition of reasonable doubt as created by the Florida Supreme Court. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. Don't worry, there's not a pop quiz. I'm not going to ask any of you to read that back to me. That's the legal definition of reasonable doubt. Now, if you're selected to be a member of our jury, you'll be given a copy of that instruction when I read you the law, and you'll be able to bring that in with you to the deliberation room while you make your decisions in this case. Raise your paddles if you agree to apply the definition that I just gave to you. I believe I see all paddles. Let me ask it this way. Is anyone not going to apply the definition that I gave to you? Raise your paddles. Court sees no paddles. Thank you. Is there anyone here who thinks that burden is just too high for the state? Beyond a reasonable doubt? Too much? Anybody have that thought? Raise your paddles now. Okay, court sees no paddles. Alternatively, does anyone think that burden is just too low? Beyond a reasonable doubt, too low for the state? Needs to be more. If you have that opinion, raise your paddle at this time. Okay, court sees no paddles. Now, nothing in the instructions that I give to you are going to tell you how many witnesses the state needs to call or how many pieces of evidence they need to provide to us to prove their case in order to convict Ms. Boone. If the state calls one witness, no exhibits, no paper, just one witness, and that witness convinces you beyond a reasonable doubt that Ms. Boone is guilty, what should your verdict be? Anybody would take a jump at that question? I think juror number 8 was slightly before you, number 17. Juror number 8, yes, sir. Speak up for me. Okay. Does anybody disagree with that? Okay. Juror 8. Oh, juror number 2, do you disagree? Yes, sir. Everything's been presented. One witness, the defense chooses not to put on a case. You hear from one witness, and that witness convinces you beyond a reasonable doubt. What should your verdict be? Speak up for me, sir. So you agree it should be a guilty verdict? Thank you. Does anyone disagree with that? Raise your paddles if you do. Okay, I see no paddles. Juror number 2. Let's change this a little bit. Let's say the state calls 30 witnesses and puts in 3,000 pieces of information. And you're on our jury and you go back to the deliberation room and you take notes, and you remember everything that everybody said. And you look intently at every single piece of those 3,000 pieces. You're not convinced. You have doubts. What's your verdict? Does anybody disagree with that? Raise your paddles if you disagree with that. Court sees no paddles. Now, the reason juror 2 and jury 8 and I had that conversation, it's not about the quantity of the evidence and testimony that the state provides. It's the quality of the evidence and testimony the state provides. Raise your paddles if you understand that. All right, record reflect all paddles have been raised. Raise your paddles if you agree to apply that. Record reflect all paddles have been raised. All right, thank you very much. The next is the right to remain silent. In every criminal proceeding, a defendant has the absolute right to remain silent. I will instruct you to follow the law as set
This
out
is so
in the
good.
Constitution of the United
I'm
States.
really happy
and
the
the
judge is doing
Constitution
this.
of the state of Florida. And it says that you cannot hold it against the defendant if she chooses not to testify. Is there anyone that has an issue with this concept? Raise your paddle if you do. Court sees no paddles. Is there anyone here who expects to hear from Ms. Boone during trial? If you have that expectation, please raise your paddle. Court sees no paddles. Now, oh, no, 39, I'm sorry, I didn't see you.
Uh-oh.
Yes, ma'am. Why is it that you expect to hear from Ms. Boone? You're gonna have to speak up for me. Do we have a microphone? Perfect. All right, ma'am. The deputy's gonna bring you the microphone. If you could speak into it for us, that would be fabulous.
No, I'm not too familiar, but I thought that if the individual is claiming to be innocent, that he or she would speak on his or her behalf to help prove their innocence.
No.
But did you hear me explain earlier that the state of Florida is the one that has the burden in this case?
The state of Florida has the burden to prove beyond a reasonable doubt.
Correct.
The defendant is guilty.
Yes.
Correct. And that Ms. Boone comes into this court, whether it be here in 23A or 12 Alpha or any other floor in this courtroom, with the presumption of innocence. She's done nothing wrong. Do you understand that?
I hear you.
Okay.
No, you don't.
So why is it that if she chooses not to testify and exercise that constitutional right, are you going to hold it against her if she does not testify?
I wouldn't say hold it against her.
You would.
No, I wouldn't say that I would hold it against her. I just thought that she would have something to say.
Okay. What if she chooses not to say anything?
It's her choice.
Okay.
This
And
juror's
if
going home.
We get to the defense case and they say, Judge, we're not going to put on a case. And you don't hear anything from the defense. Is that going to be an issue? Are you going to have concerns because you haven't heard from her?
At that point, it's just basically a matter of going with what has been presented. If there is nothing presented from her, then.
So if she chose not to testify, would you or would you not hold it against her?
I wouldn't hold it against her because it's at the end of the day, it's a personal choice.
Okay. All right. Thank you. The lawyers may have some follow-up with you.
Millennial Day says jury lady
Anyone
needs to shut up. No, this is
Sure.
exactly what this
Yeah.
is for. To let the jurors.
Or rather, if you expect to hear from Ms. Boone. Anyone else expect?
Absolutely what she needs
Go
to
ahead and
do.
raise your
This is
paddle.
her turn to talk.
All right, court sees no paddles. Thank you. A final way to think about these criminal concepts that we just went over, presumption of innocence, reasonable doubt, right to remain silent, is that I'm the judge. Because I'm the judge, I can do whatever I want. I can't. It's not how it works. Doesn't matter what I think, doesn't matter what I feel. What matters is on the wall, right up there in stone. Equal justice under the law. Every courtroom has to apply it the same way, whether I like it or not. And I'm going to ask you to do the same things. And what myself and the state and the defense are interested in knowing is whether or not the beliefs and feelings that you may have, if you can set those aside and follow the law that I'm going to give to you in this case. Does anyone have any concerns with regard to the criminal concepts that we just went over? If you do, please raise your paddles at this time. Court sees no paddles. Now, I've had the opportunity to go.
All right, it looks like they are going back into court for today, so we will. That was a very interesting exchange, but we're going to go back to live right now, and here we go. They are back. We'll get the audio, and while we're waiting for the audio, we'll do these in. We'll start here. Was it Jill Ames? Aha! It was Adara the Wholesome. Adara the Wholesome says the Boone song for this needs to be Wu-Tang cover. That'd be weird. I don't know why. That just kind of sits weird. Wu-Tang and Boone. Adara the Wholesome, thank you so much for that. We'll get there in just a quick second. Let's do it with Canonical Heat, gifted 10 Legal Vices memberships. Oh, that's the wrong button. We need this button. Thank you so much. Oh, that was a 50. You get a foghorn. So yeah, thank you for the 10 Legal Vices memberships. If you got one of those 10 gifted memberships, make sure you give Canonical Heat all the love. And Paranoia 07, member for 2 months, says love Vice. Oh, thank you so much, Paranoia. Thank you. Glad to have you here for 2 months. Stick around more, stick around longer. We love to have you. Ginger with a Soul has stuck around for 15 months. This is the most exciting jury selection I've ever heard. I love the way he's doing the jury selection. It's really, really nice to see a judge handle it that way. You want to see bad jury selection? Was it the Murdoch jury selection that we watched that was just excruciating? Flux, who's been a member for 2 years. Hey, 22 months from now, Paranoia will be here for 24 months as well. Flux says, Mocha Dick Poon XOXO, fully adjustable blow for freedom. What does sheet mean? Muhaha, yum, crockpot box. Not intentionally, and as always, Panzer Prison. That is a joke that's developed over the course of 2 years. Thank you so much, Flux. Appreciate it. And let's go, Brandon. Holy moly, this is absolutely terrifying. Imagine this person on a death penalty case. That's why they have the jury selection, so she's not on the case anymore. All right, let's go, people. Let's go a little bit louder, people.
Okay, Miss Boone is seated at counsel's table wearing the same clothing from this morning. Miss Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Well, that cures itself. Counselor?
Hey.
Thank you.
Sorry, was I late?
Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate? Yes. Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure.
Don't know why we're not saying anything. We couldn't
And of
hear.
course, providing you a printed copy, sir.
Getting a printed copy. Cool. All right. And as they mentioned, apparently what's going to happen, they're going to argue this last motion or two. Then they're going to break, go back to the jury selection, and
Bless you.
quite possibly, sometime in the mid-late afternoon, they will start opening statements. So we will wrap this up as soon as they finish this. I'll catch a couple
Have you had the
hours sleep and we'll
opportunity to
join you
review
live.
that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
And while they read that, we'll just talk amongst ourselves. We haven't seen Yoda. Yoda's been left out. Yoda's over here, just out like a light, out like a little emotional support potato pig dog light. Sarah doesn't have a chance here, but this prosecutor I've had enough of. What's your beef with the prosecutor, Christine Perkins? I quite like the prosecutor myself. What's your problem with the prosecutor? Here's the one thing the defense lawyer hasn't asked for.
I move for a bad court thingy.
You mean a mistrial?
Yeah.
I really hope Brian is fit and fine after his time away from Sarah. Well, he'll be in the same room with her again. He's one of the witnesses that they're going to be calling, so
Okay.
they'll be reunited.
All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't.
All right, sorry, I don't want to talk over these
and
people, but I have just
apologize if
lost
I was
both
not,
monitors.
in
Bear
our
with
motion,
me.
though, but paragraph 24 of the state's motion includes a quote from the Holland case However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland
We're
versus
back.
State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984.
Yes, this is not going to be the most
Also
exciting
quoting
of motion
Williams
hearings,
versus
but
State,
we're here for it.
252 Southern 2nd, 243, 246 is the page. Florida 4th DCA, 1971. Reed, REID versus State, 213 Southern 3rd, 1110 at page 1.
Even my monitors fell asleep.
Florida 5th DCA 2017. Rudin versus State, 182 Southern 3rd, 724 at page 726. Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement?
Talk to the judge, not the lawyers.
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 7 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Talk into the microphone, people.
Received and understood. Any other clarifications for the purposes of opening or trial?
This judge is
based on
former
the
military.
court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that I beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6th DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has applied to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with for Dyer nor opening statement.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Okay. Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages.
Oh, come on.
JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2,
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. Court is conducting a Richardson hearing at this time. The 81 pages are not at issue.
Use your damn microphone.
And what do the 119 pages evidence?
Your medical records from the hospital relating to Sarah Boone over a period of time. Obviously, that's going to be whittled down depending on her testimony and whether or not it was cooperative. Her testimony that she suffered an injury at the hands of George Torres.
I need more specifics than that.
I'd like to hear it too.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willful.
Okay, time to take a pause on the live proceedings here just to explain this to people. I've been Googling furiously. A Richardson hearing takes its name from the landmark Supreme Court case Richardson v. State of Florida. In Richardson, the Florida Supreme Court held that the trial court has an affirmative obligation to hold a hearing, a Richardson hearing, once it is put on notice that there has been a discovery violation. And that's what's being argued here. The prosecutor arguing that the defense violated their discovery duties. And Christine Perkins says this is why she's mad at the prosecutor. It's this stuff. This stuff is important. This is the rules. The defense lawyer is not playing by the rules, according to the prosecutor. They said, because they had originally produced like 550 pages of medical records 3 days ago. And they objected to that and said, these are irrelevant documents. They involve things that have nothing to do with this. And so they whittled it down to, he said 87 pages, I think 81, 87 pages that they gave. And he said, okay, cool. We have no problem with these 87 pages. These are the ones you plan on giving. They said, yes. And then they came in with this other document that wasn't even a document. It was just haphazard JPEGs. Was 100 and however many of them there were. They should have been all aligned in the same direction, put in one single PDF file and given it to them. But they came in after they said that this is what they were going to submit. They gave them in probably an improper format. They violated the rules of discovery. So they said, we need a Richardson hearing on whether or not this can be included. So what the judge has to do here, the court has an affirmative obligation to hold a hearing once it's put on notice there has been a discovery violation. During the hearing, a trial court must first determine whether a discovery violation has occurred. If a violation has occurred, the trial court must then consider whether the violation was inadvertent or willful. Was it an accident or was it on purpose? Whether the violation was trivial or substantial, important violation, or is it just kind of a trivial violation? And 3, whether it has affected the defendant's ability to prepare for trial. If a trial court determines that a discovery violation has occurred, the consequence can vary based on the severity of the violation. Possible sanctions may include a court-ordered exclusion of the improperly disclosed evidence, granting a continuance, I hope not, or in severe cases, dismissing the case entirely. Well, that's not going to happen because they're arguing it was the defense lawyer that violated the discovery rules. All right, that's what a Richardson hearing is. Let's see what the Richard hearing results in.
Willfulness of the discovery. I need to address whether it was Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
The defense lawyer,
Moreover,
they just wandered off. The defense lawyer just wandered off in the middle of the judge's statement. Oh, come on, that's bad for even the judge is like, hello, hello, hello. He went silent there for a minute. Lisa Bates Lester says, I'm actually an attorney in Florida. I'll have to take your word for it. Lisa is probably, well, not probably, is more qualified than me to comment on any questions you might have regarding the Richardson hearing. But wow, I can't believe they just did that. I can't believe they just wandered off and left the judge going, okay, I guess I'll keep talking. Wow, that was weird. Let's watch that again.
are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
Hello, hello, Bueller, hello.
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the three prongs that I need to address.
Oh, this judge is so patient. I'd be like, am I bothering you? Am I interfering with you? He's just like, all right, cool. This is odd. Not as odd as yesterday yet, but the recourse they would have is not allow the evidence. Say, sorry, you violated the rules in the way, shape, form, or timing of how you submitted this. So we're not going to let you bring it up.
My understanding is the first 81 pages were medical records of Sarah Boone that we got from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
Now, the prosecution said they've had those documents since 2022. Sarah Boone has had them since 2022, not last week.
Okay. I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood. All right. Well, I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down.
Okay.
They planted.
I misspoke.
The court ruled.
I misspoke. This is about the 550 pages. The other was about the 80-something page document in and of itself. All right. So anyway, the number of pages doesn't matter. It's still the principle behind it. Sorry for misspeaking there. I can't hear what the hell these guys are saying because none of them are talking into the goddamn microphone.
50 pages that we addressed yesterday.
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those?
Yes.
The VAC and the narrative?
Of course he
That's what's
wants
gonna be
the
offered
exact
into
pages.
evidence at this point in time.
The question is, well, do you want the exact pages? Of course he doesn't want the wrong fucking page numbers. Of course he wants the exact page numbers you plan on submitting into evidence, you doofus. Come on, Owens, you're better than this.
Appreciate it. So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on response.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours,
Oh, no.
I received 382 pages jail records regarding Boone.
Yesterday, after hours, you received 380
Spend my
something
personal
pages.
time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138.
I'll be right back. Don't get too
I don't
bored.
understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no.
Sorry, dude,
psychiatric
I'm boosting your
records
speed
for
to
treatment for
1.5.
Trauma, any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results. And we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. It's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Warner, opined in her deposition, that the anxiety she may be suffering from at jail was from being in jail. So there were questions about that, but generally you get these records, as you know.
Okay, this, I don't know if you heard that, but he's talking in he's just talking in absurdities. It's like tautological arguments here. The stress she was suffering in jail was from being in jail. Yeah. Okay. And
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records.
These records are going to get chucked out.
Post-evaluation, the last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence. Because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens? So she has not yet reviewed these yet, correct? Okay. Okay. State with. Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they're not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
So the arrest reports are not listed as evidence in itself, but reports may be used to refresh the officer's memory if needed during the testimony.
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
Okay.
Response?
The defendant is not intending to introduce the
Okay, the objection is sustained. 18, prior criminal history of George Torres, not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know we had some priors in Pennsylvania, Massachusetts, we're not referring to them as well, we're referring to the ones involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent? Can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony we believe is going to cooperate. Sarah Boone's testimony without injuries, photographs, officer visibly observing injuries on her. That's the nature of this. So I don't think there is going to be anything about a prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits.
So something about prior criminal
report,
history.
anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of marriage spouse syndrome, Dr. Brady testified, I see Dr. Humble testified, Dr. Warren testified, is this feeling by a victim of being battered, that she has nowhere to turn. His family can't help her, she has no room. The state attorney dropped 3 of the charges. 3 separate times George Torres was arrested, charged with violence against Sarah Boone. And her request, she wanted him off. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had murdered him. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt a threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Wood says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres when she was.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical.
We may want to introduce something in the court record indicating that the state attorney did this.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the prior criminal history.
Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19.
So great. All of that was unnecessary because they withdrew it.
Response.
That's to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21. All court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one. Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument. Okay, I'm going to overrule the objection as to as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01.
The divorce case.
-O. I understand the state's objection is to relevance and hearsay. Response?
Judge, Brian Boone, he anticipated to testify for the state, he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in court record, or we may reflect for impeachment purposes the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son, and has had full custody for 4.5 years. That was not the agreement they originally had. He was ordered to pay out on, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel Sarah Boone.
What does the non-payment of alimony have to do with what's happening in a family case?
Well, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now.
So he wants to impeach. He wants to use. He wants to try to impeach Sarah's ex-husband by bringing up court documents that he hasn't been paying alimony.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final.
Her ex-husband is a witness.
Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of a hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know, because that's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file.
Well, you better find out the ramifications before you start talking about him.
I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
Wow. All right. Well, he approaches. We got some business to take care of here. How far back do we have to do this? Take these in reverse order. Cody Hyde has been a member for 4 months. Thanks for the gifted membership. I'm always here, Vices. I just can't afford my own membership right now. You're not required to have a membership. Just you being in chat is enough. If you can do it, do it. If you can do it and don't want to do it, don't do it. If you can't do it, don't do it. I don't want anybody to do anything they can't afford to do. No, just, cool. Not a problem. Just having you here is enough for me. And CMEF Fashionable says, what happens if someone loses their marbles in jail while awaiting trial? Then they're not fit, assuming that it's proven. They're not fit to stand trial. They get treatment, and as soon as they're deemed fit for trial, they go ahead with the trial. Kim Dodds gifted 1 Legal Vices membership. Thank you so much, Kim Dodds. Jill M's gifted 10 Legal Vices memberships. That gets you a foghorn. Ooh, it almost got the wrong. There we go. Jill M's gifted 10 Legal Vices memberships. And where are we on unlocking the next level? We're farther away than I thought, but it doesn't matter. It's the thought that counts. We've unlocked the emotional support potato pig dog cam. And the other thing we do is when you get to the second level of achievement, we're actually still like $30 away. I said 60 to you earlier, but We're actually like 90. So, but what we do when we get to the second level of achievement, we do a shot of terrible whiskey as a punishment for me keeping my emotional support potato pig dogs behind a paywall. We're close enough there. Why not? Yesterday, we finally finished a bottle of Costco's Kirkland brand blended Scotch whiskey that I've been trying to get rid of for about 5.5 or 6 years. I'm running out of bad stuff. I'm going to have to intentionally buy some bad stuff. But the last real bad stuff I have, and if any of you have been watching my stream for any length of time, you'll know my feelings on this junk. Fireball. I don't know how old this bottle is. Like literally the guy that I opened this bottle with is dead. So it's it's been a long time. The guy who first shared this bottle with me is dead. It's so old the label is peeling off. So this is the next punishment. This is bad. This is just cinnamon flavored syrup. Oh God. I found this in the bottom shelf in the far back of my whiskey cabinet. Thanks, I guess. Cheers. I have not had this for years. I'm guessing this bottle's got to be 6 years old too. Because Carrie's been dead for how long's he been dead? He's been there for like 2.5 years. Oh God. Cheers, I guess. Well, hello there, counselor, or whoever you are. I'm sorry. That just kind of made the whiskey taste good suddenly. Well, hello. I'm awake now. Oh, there goes burn. What about Famous Grouse? Famous Grouse is a low budget whiskey, but it is actually quite good. In fact, that was Famous Grouse was Queen Elizabeth II. It was her favorite whiskey. And King Charles, his is Bowmore. But yeah, Famous Grouse was the Queen's own licensed and approved whiskey. It had her royal seal affixed to it. So yeah, Famous Grouse is good stuff. Oh man, I hate Fireball. Thank you so much, I guess. But I've got questions. Sarah's flanked by some hotties. Good for her. Yes, Flux. I'm all Flux. I thought you said Jeff. Flux. You're awake now too. Come on. That's a good question. I think it's just the base Famous Grouse. It might Naked Grouse. Now the Naked Grouse, that's a little bit lower. I don't think that has the royal seal on it, but just the straight Famous Grouse is the one I believe that was her preferred beverage. Wow. Oh, okay. The Fireball is hitting the stomach here. And it's just syrup in my mind. I'm actually kind of sad I found this.
I thank you all both for your arguments.
All right, let's go.
And clarifications based on the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation.
So you would say
not
Rolling
seeking to
Stones.
Utilize it. Court
You
takes no
can't
action on
always
that
get
objection.
what you want.
Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27.
Why
the
was she
video
getting
footage of
alimony?
The arrest on February 25, 2020.
The footage of the arrest. Okay, they're objecting to
Defense
that.
has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
Okay, they're both
State, you
sitting
have such
behind
item
us.
in your
They're probably
possession?
paralegals.
News footage?
News footage.
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the rule?
There is none, as the defense has advised they are not seeking to enter it into evidence.
Boone says, why is she
32,
getting alimony
another iPhone photo file name.
when no one's
Very
raising a
long, so I'm not
child?
gonna read it.
Alimony is spousal support. It's different than child support.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection. State any response.
Any and all exhibits previously listed by the state?
Mhm. Yes, sir.
Uh-oh. This requires him to walk up to the lectern here.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing
Yeah.
yesterday.
Yeah.
The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday, in limine to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish.
That's his
explaining.
job.
I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on.
Well, yeah, that's what you
Asked
do in
for any
depositions.
elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is
This has
don't
been
know
decided already.
what they're claiming that she actually did, overt act or omission that constituted second-degree murder. So because
Put him in
of
a
that,
suitcase,
we have
walked
to
away, and
list
didn't let him go when he was. Oh
because
my
we don't
God.
know. Like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be
Everyone who
relevant.
knows what she
We don't
did to
know yet.
constitute
We
second
haven't
degree
heard.
murder, raise your
I
hand.
would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second degree murder. It's a serious charge. This is not.
Oh my
it's a
God.
unique case. It's not.
Let me help you out here real quick, counselor. He's dead. That's the first element that has to be proven. He's dead. Check mark. 2, she was the cause of his death. She put him in a suitcase. He begged to get out, said he couldn't breathe, begged her to get out. She taunted him and walked the F away. She didn't let him out. She zipped him up. She put him in there. He couldn't breathe. She didn't let him out. She caused his death. And 3, it was done with a depraved mind or indifference to human life. Leaving a dude in a suitcase that's saying he can't breathe and he's begging you to get out and just taunting him saying, shut the fuck up and shh, and you walk away and go to sleep and pick him up again 11 hours later. That seems like you don't really care about human life. That's what's being alleged, counselor. Can you fucking figure it out? Owens, I like you, and I love that you're doing what you're doing. I love that you're representing her and you're securing her right to a fair trial. But come on. You know this isn't going to work. I know you've got to try something, but you've already tried this and it didn't work. Don't piss the judge off.
Not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens,
Everything that guy just said is
Mr.
bullshit.
Cacciatore,
Thank you.
myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion in limine. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner, their rebuttal state's expert. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the two prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The two prosecutors can't testify to what she said. The only two people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. I just want to make sure it meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 states list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose it. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, you know, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Okay, well, while they're taking a little break here, let's see if there's anything particular to catch up on. Oh, Kyle Cowden with, oh, well, that was a look. What was that? Let's go back and peek at that there. That's thumbnail material there. This might be my new thumbnail. All right, anyway, Kyle Cowden, how you doing, brother? Good to see you here. Torres, I need to get packed for the trip. Sarah Boone. Okay. Yoink. Duncan, Idaho. She had COVID. She's gassy. She's stressed. Wasn't getting alimony. There was an earthquake. She ran out of gas. It's like the Blues Brothers in here. And was she paying him child support? I don't think so. No. Cody Heights. Oh, we already did Cody Heights School. That catches us up on all the super chatty stuff going on here. So I guess while we wait, I just want to make a friendly reminder to all of you to please do me a favor and get down there and hit that like button. We currently have 1,117 people here and 650 likes. That's kind of like almost half of you haven't done your job. So, we need like 900 of you. Okay, not 900 of you. We need like 500 of you to get down there and hit that like button. 500 of you get down there and hit that like button. And let's see. Looking at this, I also note that we've been blessed with more subscribers today. We are currently sitting at 81,213 subscribers. That means we've picked up about 20 since we started, but I know more of you want to subscribe to the channel. So please do me a favor and head on down there and hit that subscribe button. Sarah's judging you right now. You haven't hit the subscribe button, so Sarah's judging you. Sarah's judging you. This is going to haunt your dreams for the rest of your life unless you hit that subscribe button right now. Just saying. She's mesmerizing you with the eyes of Sarah Boone. She's mesmerizing you. So, stare into her eyes, stare deeply into her eyes. Please hit the like and subscribe button. Come on over here and take our like and subscribe poll. It looks like we're going to be shutting it down here before too long, but the question is, what is your preferred snack while watching the Sarah Boone trial? 16% of you say Pop-Tarts. Korea had Pop-Tarts for about 5 minutes at Costco one day. I do miss Pop-Tarts. Chips or crisps, potato chips or crisps, depending on your country of origin, 23%. 27% of you say popcorn. I am a popcorn honk. I love popcorn. And 35% of you in the number one slot, you say gummies. You need all the gummies to get through this. So take that. Please hit that like. But we got 700 likes. We should be up to 1,000 likes by now. We should be up to 1,000 likes and 82,000 subscribers. We just need like 800 more subscribers. Come on, get down there and do that. All right. So what we're going to do here is I'm going to keep an eye on what's happening in court. Let's fast forward. All right. This is Mr. Clock, and the clock is going to show up on the bingo card. And for those of you that are not regular viewers of the channel and you're just finding this and you're just subscribing, when we do the trial, we also do a bingo card for things that you'll see or hear. Either here, usually there's like things like dog snorings, possibly me falling asleep. Clock. We'll have to chat. Your job is to think of a good name for the clock. We need and something better than Clocky McClockface. In our previous trial, Karen Reed trial, we had the ceiling fan, which we called Ceiling Dion. We need something clever for the clock like that. But we'll have a bingo card, which seems a little bit irreverent, but the purpose of the bingo card, it actually helps you focus a little more on the testimony because you're listening for things that are in the bingo card, but that also helps you listen for other things, just normal things that don't have anything to do with bingo. So it'll help you stay focused, help you stay a little bit alert, and it's kind of a fun conversation piece. So I will whip us up the official Sarah Boone bingo card for tomorrow. We won't get it for opening statements because that's going to happen while I'm preparing. We don't have enough time to prepare the bingo card. But all right, that's it. And again, is a real quick thing. Or what I understand is they're going to finish these arguments. The judge is going to give his ruling. They're going to shut down. They're going to go back to do more jury instruction, more jury questioning to seat the jury. And the defense, they believe that it's going to take an additional 2 hours. So I would assume once they shut this down here, it'll be about 3 hours before they start the opening statements. And during that 3 hours, I will hopefully be asleep for the vast majority of that time. And I have at least 3 people that'll be calling me to make sure I wake up when they're getting ready to start the opening statements. And we will do a live stream of the opening statements right here. So do not miss that. And we have a few more things that have rolled in here. At least one more. Canonical Heat dropping another 20 for the Better Booze Than Kirkland Scotch Fund. Thank you so very much. Flux has already thrown in a private text message with Kelly Clarkson. Uh-oh, somebody's going to have to come up with something better than Kelly Clarkson, because I'm kind of liking that one. All right. Clockwork Orange. Nah, it's got to be Clock Griswold. No, it's got to be better than Kelly Clarkson. Don't even suggest it. If you're not 100% confident, it's better than Kelly Clarkson, because Kelly Clarkson is fire. All right, let's go watch yesterday's. We'll resume with yesterday's jury selection until they come back to court here in a few minutes. Kelly Clarkson, it's got to be better. Don't even suggest it. Big black cock. No, not big black clock. No. Fast Dad 16. That's 5 minutes in the penalty box for instigating. Come on. No. All right, let's go.
Over the last couple of days to get to know some of you. We have all different persons from different walks of life. We have stay-at-home mothers, we have security personnel, engineers, CFOs, recreation coordinators, sales reps, and managers of hotels, all different walks. Now, when I give you instructions on the credibility of witnesses, there's not going to be a different set of rules for hotel managers, sales reps, stay-at-home moms, engineers, or CFOs. They're all looked at equally. The same goes for law enforcement. Is anyone here going to believe a law enforcement officer just a little bit more because they're a law enforcement officer?
You should actually
Do you have that belief?
the opposite.
Please raise your paddle at this time.
You should believe them a little less because they're law enforcement
Court sees
officers.
no paddles. Flip side of that coin. Are you going to believe a law enforcement officer just a little bit less because they're a law enforcement officer?
Yes,
You have
don't
that
admit
opinion. Please raise your paddles at this time. All right, court sees no paddles. My last topic involves any personal experiences in the criminal justice system. Have any one of you or your immediate family members ever been arrested? If so, please raise your paddles at this time. I'm going to start over here on my left. I have 1 and 6. You go ahead and put those down. Thank you. No, second row, keep about 15 and 19. Thank you. And 29. All right, thank you very much. And over here on my right, 8. Thank you, sir. You put that down. 22, 26, 27, 38, 39, 40, 48, 49, and 53. All right, I'm going to start over here on my left. Juror number and seat number 1, afternoon. Who was it? Yes, sir. Who was it in relation to you? Okay.
All my family are criminals. They've all been in jail.
Okay. Did those take place here in Orange County? Oh, some of them did. Okay. Do you recall who specifically that may have happened here in Orange County? Okay. And what about your father? Okay. And do you know if they were taken to court?
I figured they would start them either today or tomorrow.
How long ago was both your brother and your father? Ballpark it for me.
I was leaning towards tomorrow, but
okay, so 10, 12 years ago? Okay. But can you say for certain whether or not they went to court? Okay. Do you have any personal knowledge as to whether they were represented by an attorney?
Full disclosure here, Flux has just informed me. I thought Flux was the one that came up with Kelly Clarkson, but she has just informed me that it was, in fact, Alyssa here in chat that came up with it. So kudos and all hail, glory, laud, and honor goes to Alyssa, because I haven't seen something better than Kelly Clarkson coming up yet. Although Lone Star did say, I'm old, so Eric Clockton. Noble effort, but it's not going to beat out Kelly Clarkson, I think.
Okay. And do you have any personal knowledge as to whether or not they were treated fairly? Okay. Your father and you had other extended
My
family
father
as
and
well
my
that
brother
you had
both
gone through.
deserve
Is
to
that
be
here
in
in
jail. Yeah,
Florida
they
or
were
other
treated
states?
fairly.
Okay. Do you know in those instances if those family members went to court? Do you have any personal knowledge if they were represented by attorneys? Okay. Do you have any personal knowledge as to whether or not they were treated fairly through that process? All right, your brother and father's experiences in the criminal justice system here in Orange County, along with your extended family's experiences in the criminal justice system in the state of Florida generally, are those going to have any impact on your ability to fairly and impartially weigh the evidence in this case? Okay, thank you, sir. Juror number 6. Afternoon, sir. What happened, who, and when?
Me.
Where was that, sir? Did you go to court? Were you represented by an attorney? Do you believe you were treated fairly through that process? Your own experiences in the criminal justice system in the state of New Jersey, will that have any impact on your ability to fairly and impartially weigh the evidence in this case? Shouldn't?
It shouldn't.
Okay, thank you. Juror in seat 15. Yes, sir. Also up in New Jersey? When did that take place, sir? When in time?
One moment in time.
Do you have any knowledge, sir, if they went to court? Do you have any knowledge if they were represented by attorneys? Do you have any knowledge as to whether or not they were represented by attorneys? Okay. Do you have any knowledge as to whether or not they were treated fairly through that process? Thank you for your service, sir. Your brother's experience 30 some odd years ago in the state of New Jersey in that criminal justice system, will that impact your ability to fairly and impartially weigh the evidence in this case? All right, thank you, sir. Juror number 19. Well, when was that, sir? And where was that? Okay. And do you have any knowledge as to whether or not he went to court?
He did. He had an attorney I was living in the state. I called him. He said he served 3 days in jail.
Okay.
He admitted.
Do you have any knowledge?
Oh, good Lord. It'd be easy to say, please hold up your paddles if you don't have a family member who's ever been arrested and gone through the criminal justice system. Holy crap.
Okay, so fair and impartial? No, he was treated fairly through that process? And is that going to have any impact on your ability to be fair and impartial in this case? Thank you, sir. Juror number 29. Hello. I may need her to get the microphone because you're even farther back than everybody else.
Hello.
Hello.
It's an estranged uncle of mine.
Okay.
I was in middle school and high school, so that had to have been like at least 15 years ago.
15?
About there, probably.
Got it. And where was that, ma'am?
It was here. I know in Florida. I know he's been arrested several times. I'm gonna guess some of them were in Orange County, but I don't talk to him. My mother does. None of us talk to him that are close to me.
Okay. Do you have any knowledge if he went to court in any of those?
He did. My understanding is he has 2 felonies.
She sounds so sweet.
Do you know if he was represented by an attorney?
I do not.
Do you have any knowledge as to whether he was treated fairly through those processes?
Yeah, he did that stuff.
Okay.
Uh-oh.
Your uncle's experience 15 some odd years ago, both here in Orange.
I'm sorry, but Sarah McLaughlin, that's a good one. Sarah McLaughlin. I like that. That's good.
County and other places in Florida. Will that have any impact on your ability to fairly and impartially weigh the evidence?
No.
Okay, thank you.
Welcome.
Hey, anyone else on my left, you or immediate family member been arrested? Please raise your paddles. Court sees no paddles. Moving over here to my right, juror in seat number 8. Yes, sir.
My brother was arrested last year for assault in Florida.
He was like, super Galte. I'll be right back. The seal has been broken.
Do you believe he was treated fairly through that process? Would your brother's experience, would you recall where out west, sir? Okay. Your brother's experience in the criminal justice system in the western part of our fine United States, was that going to impact your ability to fairly and impartially weigh the evidence in this case? All right, thank you very much. Moving to juror in seat 22. Ma'am. Well, at least he got there on time. Okay. Do you know when the New York arrest happened and when the Kosovo arrest happened? Okay. And was the other arrest before or after that?
And the court is still in recess. I'm watching.
How recent is recent? Okay. All right. Thank you. With regard to the arrest in New York City, do you know if he went to court? Okay. All right. Your brother's arrest in New York City, is that going to have any impact on your ability to be fair and impartial in this case? Okay. All right. Thank you, ma'am. Juror in seat 26. Do you believe you were treated fairly through that process?
That's kind of good too. Clockwork
Your own
Owens.
experience in the criminal justice system in Polk County, is that going to have any impact on your ability to be a fair and impartial juror in this case? All right, thank you, sir. Juror in seat 27. Hang on, we're going to hand you the microphone. Madam Court reporter's having a difficult time hearing you.
When I was 16, I was arrested for violating probation.
Okay.
And I was out of state. Also, my
Well, now wait, if you're arrested for violating probation, you were arrested before that too. You have to be arrested and you can't say I was arrested for violating probation. You were arrested for something before that. You've been arrested twice, brah.
my father, maybe 25 years ago, was arrested. Also out of state.
Which state?
New York State.
In New York? Okay, thank you. And sir, with regard to your father, did he go to court?
Yes, he did.
Was he represented by an attorney?
As far as I know, he was.
Do you have any knowledge as to whether or not he was treated fairly through that process?
I would assume so.
Okay, and with regard to yourself, sir, did you go to a juvenile facility or juvenile court?
No.
Were you ever represented by an attorney?
Yes, I was.
And do you believe you were treated fairly through that process?
Yes.
Your own experience and your father's experience in the criminal justice system in New York, be it adult or juvenile, is that going to have any impact on your ability to fairly and impartially weigh the evidence in this case?
No, sir.
All right, thank you, sir. Juror in seat 38.
Hello.
Yes, sir.
How are you?
Let's use the microphone with you as
Hello.
well.
Okay.
Oh, you got it. All right, thank you, sir. What happened?
My brother was arrested back in Pittsburgh in about 2008, 2009.
But in fairness,
And did he
everybody
go
in
to court,
Pittsburgh
sir?
has been
As
arrested.
far as I know, we did, yes.
Was he represented by an attorney?
Sure. I'm not too familiar. I was younger, so, but yes.
All right. And do you have any knowledge as to whether or not he was treated fairly through that process?
I would say so, yeah.
Okay. Your brother's experience in the criminal justice system in Pittsburgh, is that going to have any impact on your ability to fairly and impartially weigh the evidence in this case?
No.
All right, thank you, sir. Juror C39.
Yes, hello.
Yes, ma'am.
Death clock is good.
My stepbrother and stepfather were both arrested previously.
When and where?
My stepbrother, I believe it was probably about 30 years ago.
Okay. And your mother, stepmother?
Stepfather.
The stepfather and stepbrother.
Correct.
Okay, thank you. And your stepfather, how long ago was that?
Probably about 15 years ago
Where was that?
in Orange County. Well, for my stepfather, it was in Orange County. For my stepbrother, I believe it was in Virginia, and then he was transferred somewhere else, New Jersey.
It was transferred from Virginia to where?
I think New Jersey.
Okay, all right. And do you have any knowledge as to whether either of them went to court, be it in Virginia, New York, or here?
My stepbrother went to court. I was in college at the time, but he went to court. However, I don't believe that he had an attorney that we paid for, that the family paid for. So he was probably represented by a public vendor.
Okay. And what about your father? Your stepfather, excuse me.
I can't remember. I just know that I posted the bail.
Okay. Do you have any knowledge as to whether both of them were treated fairly?
I don't think that my stepbrother was treated fairly. He served 27 years.
What about your father?
I believe he was.
Your brother's experience and father's experience in the criminal justice system, will that have any impact on your ability to fairly and impartially weigh the evidence in this case?
I don't know.
Okay. Well,
okay.
I don't know because, like I said, there were two different experiences, and I saw each experience differently.
okay.
Interesting.
All right, ma'am. I appreciate that. The lawyers may have some follow-up with you on
Yeah.
that. Thank you.
She's going to be gone.
40.
Hello.
Hello.
Hello. She sounds like the other one.
My
Oh,
dad
all right,
and-
people. The judge is back in court. So enough of that. Let's get back to present day Boone. Where's present day Boone? Just present day Boone. This is present day Boone. All right, got to change the banner
All right, we're
again.
back on the record, case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. The defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was cured.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
Right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the Orr-Tennis motion as to Ms. Boone's request for snacks, the Orr-Tennis motion is denied. Ms. Boone is being
No snacks for
provided all
you.
the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Look at Sarah. Look at her. Sarah. Laser eye. She's looking into your soul, people. No snacks for you, Sarah. This is the look. This is the expression of a woman who's been denied free snacks by the court. Suffer, Sarah. Suffer. No snacks for you. But we have snacks. If take the like and subscribe poll, we've got 1,120. Don't anybody leave because we're talking about what's happening next here. Don't anybody leave. Do not leave. We're going to be talking about what's going to be happening over the next little while here. But first, we have our like and subscribe poll. 1,126 of you, 784 likes. Come on, people. We need 220 likes. Let's get up to 1,000 likes. We got to 1,000 likes yesterday. Are you worse than yesterday's chat? Are you? I don't think so. You're better than yesterday's chat. We're better every day. So let's get us up over 1,000 likes. And take our like and subscribe poll. Subscribe too, by the way. We are currently at, where are we sitting with subs? We are sitting at 81,231. We picked about 40 some odd, maybe 40 subscribers today. Cool. That's cool beans, man. Hit that subscribe button and take our like and subscribe poll, which is going to be shut down here in about 20 seconds. What is your preferred? Sarah got denied her snacks. Taxpayers of Florida, you can rest at ease. You do not have to pay for her snacks. What is your preferred Sarah Boone snack? The preferred Sarah Boone snack for you. So that's what is your preferred snack while you're watching the Sarah Boone trial? 15% of you said Pop-Tarts. That's one thing that I think she wanted. She wanted Pop-Tarts. 23% of you says potato chips or crisps, depending on where you're coming from. And 27% of you said your preferred Sarah Boone snack is popcorn, which I'm a huge popcorn fan. That would be my choice. And what is your preferred Sarah Boone snack? 35% of you said gummies. All the gummies. All the gummies. That's your preferred snack. You need the gummies to get you through the Sarah Boone stuff. Right. So they are on break right now. They're on break and they're coming back at 1 p.m. And the defense lawyer said he's going to take about 2 hours to finalize his questioning of the jurors, and that will be when we get the juror set. So I'm expecting opening statements to start perhaps 3.5 hours from now, something along those lines. So what I'm going to do is currently where I'm at here in Korea, it is 12:30 a.m. Oh, so he's starting at 1 p.m., which is 2 a.m. my time. Oh my Lord. So about 4 a.m. my time. When they get ready to sit down, I have about 3 people that are going to call me to make sure I wake up. So that'll be around about 3 p.m., 3 to 4 p.m. I would expect. So they're probably going to do openings. They might, that's kind of late. They might just start with opening statements Friday. I don't know. I'll be asleep. If I get a phone call, I'll wake up. If I don't, I won't. That's it. But stay tuned here. Make sure you've hit the subscribe button. Make sure you've clicked the bell for the notifications. And when I put something live, we'll go. So whenever the opening statements are, we'll be doing it live. Now we have to resolve the name of the clock. The next time when we start opening statements, whether it's in a few hours or whether it's tomorrow, I'll put up the poll for you all to decide on the name of the clock. We need to name the clock. Like I said, during the Karen Reed trial, we named the ceiling fan Ceiling Dion. Now the choices, and I'll be thinking about it and you'll be thinking about it. The choices for naming the clock will be Kelly Clarkson, Clock Kent, Boone's Day Clock, or Sarah McLaughlin. those are hilarious. Hang on. We have our in-court reporter on the line here. Hey, Jules, what's up? Oh, she's not here anymore. Okay, that was quick. All right. We almost had a discussion with our on the scene reporter. Jules in chat is in the courtroom for this. So we'll get in touch with her. But all right. So those are our names: Kelly Clarkson, Clock Kent, Boone's Day Clock, and Sarah McLaughlin. We'll put that up for a next poll and allow you who attend the next stream we do, the opening statement stream, to determine the name of the clock. And that'll be added to the bingo card that we're going to be making for tomorrow. So, all right, everybody, that's what I'm going to do. We're going to shut this bad boy down. I've already set up a private stream, and I've privated it. So as soon as somebody calls me and tells me to go live, that's what I'm going to do. I'll be, oh my God, I'll wake up and go, oh geez, they're going to do opening statements. I better get on over there. Better get on over to chat and start my stream, which was what I'm going to do. So bear with me until then. I'm going to be taking a nap. You guys go about your day and check back every now and then, make sure things are going well here. And I will see you when the opening statements actually happen. So I think we've got everything taken care of until opening statements start, people. I'm going to peace out. So, mods, thank you so much for doing your moddy best. Thank you. We currently have 1,010 people still here. I'm sure you're all subscribing and smashing that notification button so you get the notification for when I, the world's premier lawfluencer, begin my opening statement stream. Of course, that's what you're doing. Thank you so much for the griftathon and getting us to day 37 of the emotional support potato pig dogs. That is super awesome. And thank you for the super chats, the gifted memberships, the purchase memberships, and thank you for just being here in chat. And if you're a big Smiths fan, a fan of the Smiths, I've had the song "Boyfriend in a Suitcase" running through my head the entire day. Boyfriend in a suitcase. I know it's serious. Anyway, Thank you very much. I will see you in either a few hours or in about 20 hours. It's up to the court. Thank you, people. Love you all. Me, Legal Vices, wishing you the best of the next few hours or day, depending on how long it takes us to get back. Take care, everybody. See ya. I would love to be Oh, wait. Whoa, rare in history. Member for 25 months says my vote goes to Boone's Day Clock. Crystal Pooh, you genius. All right, that's the last one. Now, see ya. I would love to be ya. Bye, everybody. Me, Legal Vice, saying peace out until we meet again. God be with you till we meet again. Bye.